Call the second case on this morning's docket. That is case number 110061, State of Kansas v. Smith.
May it please the court, Shelbert Smith appears through counsel Michelle Davis. May I please reserve 3 minutes for rebuttal?
3 minutes is granted.
This is a case where Mr. Smith had entered a plea. It was at a time in 1993 when there was a 120-day callback. So at sentencing, the judge said to Mr. Smith that my decision is not final. Once I receive the KDOC report, then I'll render a final decision, then your attorney can communicate that to you. Recently, several years ago, Mr. Smith filed a notice seeking a motion seeking a late direct appeal from sentencing, and also really seeking to withdraw his plea. He was unhappy with his attorney. The district court appointed this office, and this court then sent the case back to the district court for an Ortiz hearing. The district court denied Mr. Smith a late direct appeal, and now we're back in front of this court on that issue. So the district court really didn't find whether or not Ortiz exception was met or not. The district court really just couldn't get past the delay between the sentencing and the appeal. And I would just submit to the court that that's not really the factor to consider. Ortiz has 3 very narrow exceptions. Ortiz doesn't really go into the subjective state of mind of the defendant. Ortiz doesn't go into whether there was a waiver or not. In Ortiz, the first exception is that you're notified of the appeal and the time limit for doing so. And then all of that language about letting the matter rest really goes to that first exception, that you are aware of your right to appeal the time limit and you don't exercise that right.
Now, Counselor, the request, as I understand the allegation, is that your client requested his attorney to appeal prior to the callback period.
Yes, Mr. Smith said he wanted his attorney to appeal after sentencing.
So he went off the KRDC, apparently acquiesced in the delay to file the appeal.
Because his attorney told him to wait and see what the judge does, wait and see what the final decision is.
But we have nothing to indicate he did not acquiesce in that delay. Was there a renewed, and the reason to wait is to see what the evaluation is and see what the court is going to do. There's no reason to appeal if you get a modification, right?
I assume that was his lawyer's reasoning.
Is there any evidence, or did your client allege that he renewed his request for attorney to file an appeal after the modification hearing?
Yes, he said that he and his mother both tried to get a hold of his attorney.
Well, I understand there was an attempt to get a hold of his attorney, but do we have any, did he say that there was a communication to the attorney?
He was not able to get a hold of his attorney. And that's what's interesting about this case. For example, in the Gill case, that was a situation under the first Ortiz exception where it wasn't timely. He wasn't told the time limit. And under the first exception, you have to show that you wouldn't have let the matter rest, that you would have asserted your right to appeal. And in that case, for example, the defendant had corresponded with the court and had expressed interest in obtaining documents to file a 1507. So there was information in the record to show that even if he had been timely informed, he would not have asserted an appeal, because for years he wrote to the court and he never expressed any interest in taking an appeal. So there was something outside of what the defendant said to contradict what he was asserting, and that's the Gill case. And similarly in the Cole case, there was correspondence from the defendant to the court focusing on filing a 1507. And then the defendant filed a motion to correct an illegal sentence several years later, but never expressed any interest in a late direct appeal. And so in that case, in the Cole case, they said the record doesn't support that you were interested. The Cole case was the third exception where he said, I told my attorney to appeal. But then by the record, you could see many years passed, and he couldn't assume there was an appeal because he was pursuing other actions. He was pursuing a 1507. He was pursuing other things. So they said the record doesn't support that. In this case, we don't have any of that. All we have is a defendant's testimony, because there was no correspondence, there were no other actions taken. So there's
Counsel?
nothing to contradict, yes.
I'm wondering if just the sheer weight doesn't help to contradict, though. If we go to the third exception, it's about you've been, you know your rights, you've been appointed an attorney or provided an attorney, and the attorney fails to perfect. That's the exception you're trying to invoke.
Yes.
So doesn't the 18 years, at least, isn't it relevant to whether the defendant would have appealed? I mean, isn't that still outstanding on the third exception?
But that really goes to the first exception, because he's already said, I did appeal. I did express an intent to appeal. So really
He
it
says
just goes,
that. That's one piece of evidence. He
Right.
says, I asked for it.
and so the question really goes to whether there's evidence to support that or not, to whether that's
Exactly.
credible
And isn't
or
the
not.
18 years relevant to that question? In addition to his testimony that he did ask to appeal before the 120 days? I'm
I
just
think-
saying, isn't it relevant still
But
to the third exception?
the problem with that is all of the Ortiz, this case law specifically said the defendant's subjective state of mind doesn't come into play here. It specifically says you don't have, in fact, waiver really shouldn't come into play because.
It has to come into play on whether the defendant would have appealed. We have said that the defendant still needs to show he or she would have appealed.
Right, but
And
not,
so doesn't the subjective desire and get up and go of the defendant matter on that question?
right, the defendant has to show that under first exception that I still would have appealed, that's true. What I'm trying to say is that there's no requirement.
It's not just under the first exception. The defendant always has to show that he would have appealed.
but
That's
under
always part of the exceptions, isn't it?
Right, but under the third exception, he's already claiming that I did communicate that I want to appeal.
I understand
My
he's
attorney
claiming
just
that.
didn't do that. So really his state of mind. I think what I'm trying to say is that there's no requirement under Ortiz that the defendant make a decision, an informed and knowledgeable decision not to appeal. So the state and the court don't have to show that. They
Okay.
don't have to show.
Can we go at this a different way? Your evidence is defendant's statement that here's what I said to my attorney. The attorney is deceased, so there's no way that can be controverted that way. But the trier of fact still needs to believe that testimony. The credibility of that statement is fair game for the trial judge or the district court,
That's
correct?
correct. Yes.
So the fact that this laid without objection to anyone else for 18 years would be relevant to the credibility of his statement now, 18 years later, that he really, really wanted to appeal back then.
And that he
Would
did.
it not?
That he did. Yes. That he did communicate that to his attorney. Yes.
And that comes into play on both, on the third exception as well as the first exception.
Yes. I mean, I agree with that.
Okay.
From that point
That's
of
all
view.
I was trying to get
of-
agreement on.
I understand. I mean, I understand what you're saying. His credibility, yes, it would go to that. But all that I'm trying to say is that this idea that he somehow gave up, he made a decision not to appeal by his inaction. I mean, that really doesn't come into Ortiz.
Why doesn't it? When Ortiz says, a defendant properly informed of his appellate rights may not let the matter rest and then claim that he did not waive his right to appeal.
Right, but in this case, he's saying, I didn't let the matter rest. I communicated this to my attorney, and
But
my
he-
attorney,
But he did.
He
for
let it rest from
decades.
2005, from 1995 to 2000.
right, but then you're getting into waiver. What you're saying is.
And that's the language of Ortiz. They use it in terms of waiver.
Right, but that's not really part of the equation. I mean, if waiver was part of the equation, then we would be asking attorneys to obtain waivers. If you're gonna say, we don't require attorneys to obtain waivers. In fact, we don't require any proof that the defendant waived. All that we require are those three exceptions.
No, it's more of an estoppel is the way I see,
Mm-hmm.
see Ortiz setting it up. Granted, we don't ask for that written waiver or proof of a knowing waiver at that point, but it seems to me that this language in Ortiz, as I said, sets up almost an estoppel sort of situation. If you're going to let it languish for decades, we're not going to give you an opportunity to go back and open the case.
But you're adding another factor in there. I mean, if the third exception is that your attorney didn't perfect the appeal, but you're adding in something else if you're then going to say, we're gonna say that assuming you did tell your attorney to appeal, right? Because there's no evidence here to contradict that.
Why would
That's
we
That's
not?
not true. That's what we're trying to
You're
get
trying to say that
There-
the
there
delay
is
is-
evidence
okay.
to contradict it because there was an 18-year delay between the time he couldn't reach his attorney and decided to give up and the time he filed. That is evidence to the contrary on whether he desired to appeal.
Okay, that's fine, that's true. But that's not, you can't, then, the next step of saying, well, we're going to infer a waiver from that delay is something different, because that's not in the Ortiz exception. Waiver's not part of the requirement. So if you want to say you let the matter lay too long shows your intent, and whether you did communicate that is separate from saying,
It really
we're gonna
wouldn't be a
waive.
waiver, would it? It would be an
It's not a
abandonment.
waiver.
It would be an abandonment, if anything, because he didn't waive his rights, he asserted them. He just didn't reassert and reassert and reassert to anyone
Right, yes,
after that first year. So
yes.
we're talking about waiver, but we're really talking about an abandonment of his right to appeal, aren't
Yes,
we?
I can agree with that.
And why wouldn't that abandonment, the policy of that abandonment apply as well to the third exception as it does to the first, where that language is found?
But I think it still has to go back to, he told his attorney to perfect an appeal. And the abandonment of that, there's just not case law on it. I mean, I haven't seen case law in this state on that issue. So I think you would be creating new law on that, because if there's no waiver, if you're just under the third Ortiz exception, then you're putting some sort of additional requirement on them. Assuming that he wanted to perfect an appeal. I'm not sure I'm answering your question, but I'm trying to get there. Assuming that he told his attorney and he expected an appeal, and then at some point the appeal never materialized. His testimony was, I didn't know what to do until I found somebody at the prison that could help me. And at that point, I asserted my rights. So at some point, if you're going to bring in abandonment, I'm not sure when you bring that in. At what point has he abandoned? That concludes my comments.
Any more questions? Thank you, counsel. Counsel, before you start your arguments, for the benefit of our visitors, could you give us about a 60-second overview of what the underlying crimes were and why we're dealing with this situation?
Certainly, Chief Justice. Good morning. May it please the court. Assistant District Attorney Lance Gillette on behalf of the state of Kansas again. To briefly touch on the facts, in October of 1993, the defendant, a 16-and-a-half-year-old young man, and two co-defendants engaged in a plot to kidnap and rob a pizza delivery driver in Wichita. They ordered a pizza to an address that was not associated with them. All three were armed with firearms. They forced the driver back into his car once he arrived with the pizzas. They drove him out into the country, got him out of the car, shot him 3 times, severing his aorta and killing him, leaving him in a ditch in Sedgwick County, and then took his car and returned home. The defendant was prosecuted as an adult and chose to enter a plea with the advice of counsel, and that's what brought us here today. Then 19 and a half years later, he for the first time makes any indication in the record that he requested an appeal.
Thank you, counsel.
I think that whether we characterize the instant case and the issue here as estoppel, abandonment, or waiver, I think it is the same, and it is a threshold question that has been recognized since Ortiz, that those Ortiz exceptions are extremely limited, and a defendant cannot do nothing.
But that's not the argument here, that he did nothing. That he testified under oath that he asked his attorney to appeal. That's not doing nothing.
That's not doing nothing.
And where in the language of Ortiz does it say that the defendant has to reassert, be persistent, take further actions other than, under the third exception, request attorney to appeal?
I don't know that there is any indication or requirement that they must reassert or reassert and reassert.
Well, the district court said that he let the matter rest, and that's sufficient to lose. Where in the law does it say that if you're not aggressive in reasserting or asserting to someone other than your attorney, that's letting the matter rest? Do you understand what I'm trying to ask you here?
I think I do, and I think the question is whether or not there's not a requirement that you be aggressive, but there is at least there has to be a requirement that you do something. And granted, he claimed that he did request of his attorney immediately after sentencing that he take an appeal. However, as Justice Johnson, you pointed out in the first portion of argument today, there actually was nothing in the record that indicated he subsequently renewed a request to appeal after his 120-day callback. And I think that was my point as well, is that there's nothing at all in the record. And I think that this court is well-versed and experienced enough in these Ortiz matters to know that you don't necessarily have to do much. You just have to do something. If you've requested something be done and it's not done, you need to do something about it. Otherwise, your argument does fall on deaf ears. And I think that's ultimately an appropriate outcome when you wait for 18 and a half or 19 years and the counsel who you now wish to fault to your own benefit is deceased, cannot defend themselves.
But we have to infer or speculate that the district court was questioning credibility as to whether he would have taken an appeal if he really wanted to, if the attorney had done what he wanted to. Don't we? That there was an abandonment, because the district court just says if you delay, then that's it. That the delay per se precludes an out of time appeal, and I don't think we're there, are we?
I don't think that's what the district court said either. I think that the district court relied on the Cole case, and in the Cole case, which also relied on Patton from this court, this threshold matter in not delaying basically serves as a type of prejudice requirement. So what we're really talking about here is the delay and the prejudice. And in this instance, the prejudice is obvious. I mean, we're 19 years down the road. Defense counsel is deceased. The state cannot rebut the defendant's claims.
Well, let's go back to Patton. Patton said if the attorney fails to file a requested appeal, that raises a presumption of prejudice.
Correct.
Okay, so we're starting with we presume the defendant's prejudice. Then he must show that, but for the counsel's failure, he would have taken a timely direct appeal. And what in the district court's ruling leads us to believe that the court found that the presumption had been rebutted?
I don't know that there's anything beyond the reliance on the Cole case, and that the prejudice actually is the state being prejudiced at that point, and that appears to have outweighed any presumed prejudice to the defendant here.
Yeah, but that's not the question.
Okay.
The prejudice question under the Patton analysis is prejudice to the defendant. So are you saying there isn't anything? I think this is the snag for you here in the brevity and possible lack of completeness of the district court ruling. I mean, we really don't have anything that kind of follows the questioning line that we were posing to your opposing counsel about the credibility or about this subsequent need for the defendant to demonstrate. Once there's been proof that there's been a request and then the lawyer failed to perfect this subsequent or additional requirement that the defendant would have appealed. And that's where the snag is here for you, because the district court really didn't analyze that in the language of Patton. and didn't talk about credibility of the defendant.
Well, I think whereas this is Your Honor's characterizing it as a snag, I guess the only way I could envision that as a snag is that the district court here did not go through the full Ortiz analysis because it stopped at that threshold question.
Well, what makes it a threshold question?
I think that the threshold matter is, as was recognized in Patton, that the defendant who's been properly informed of his or her appellate rights cannot let the matter rest and avoid waiver. And
That language is in relation to the first exception.
I believe that applies unanimously to all three. And it was citing language and dealing with the specific constitutional rights to appeal. So I believe that the district court here properly relied on the inordinate delay on behalf of the defendant, and that 19-year period of time constituted letting the matter rest, a waiver, and that the defendant should be found to have abandoned or be stopped from seeking an out-of-time appeal at this late date.
In your mind, let's look at the reality of the situation. We have a 16-and-a-half-year-old who understood that he asked for an appeal, but after the original sentencing, basically had no other contact with his lawyer after the 120-day callback, in spite of, at least as he testified to, his attempts over the next year with himself and his family to contact his lawyer to ask about an appeal. And then he just he's 17 years old, and he just gives up at that point. Is there some time along in that continuum of time where it's too late, that abandonment takes, is it within a year, a couple of years? What's, in your mind, what could have been done along that spectrum of time?
I think there kind of are two questions there. And the first, Justice Rosen, would be, I don't think there is a bright line.
Well, clearly not a bright line, but yeah, this.
But in this instance, I believe that the defendant's own testimony belies the fact that he desired to take an appeal, not only due to the delay, but he expressed his ability to communicate also with his family and with prison officials to seek help and to do things and get things done for himself. Where was any of that? Any indication that he desired to take an appeal for 19 years? It's non-existent. And I mean, if he had done anything, we may have a different situation here, but he did not.
After he asked his attorney. You said he didn't do anything, but we have testimony that he asked his attorney to appeal. And that is usually the trigger of a presumption of prejudice if the appeal doesn't get filed. I'm just concerned you keep saying he didn't do anything, and we have evidence to the contrary of that.
And just to a certain degree that is correct, but as Your Honor also pointed out, he then acquiesced in not doing anything at that point and never renewed the request once his sentence was final after the 120-day callback. I believe that the record here is sufficient and that the defendant here waived his right to take an appeal, and that the district court's finding that his doing so, waiting for 19 years, constituted an effective waiver of his right. If this court has no further questions.
I'd like to delve a little bit further into the test for let it lie.
Okay.
And is that just a we know it when we see it kind of thing? Are we going to draw some analogy to the case law about latches and post-conviction? It's probably more developed in some other jurisdictions than here, perhaps. I mean, where do we go with this?
You know, I think that latches is one way that one area that you can go, and I mean, it's again just another name for the estoppel or waiver. But I think,
Except latches is an equitable remedy, and this is not equity, is it?
I think that that's arguable because in this instance you end up with prejudice on both sides, and there has to be at least some way to resolve that. And I think it does to some degree turn on we know it when we see it. And it would, if there's 1 year down the road, it's hard to imagine there would be much, if any, prejudice to the state, barring some extreme circumstances. But when we're this far down the road, I think that you start to touch on the prejudice to the state in that it gets difficult to divorce the defendant's real objectives from his request to take an untimely appeal. He wants to try to withdraw his plea and to eventually seek a new trial. And it's very difficult to divorce those two, especially when we start talking about equity here. And I think that reasonable people would see a 19-year delay as an effective waiver. And I don't know if I'm answering your question exactly, but the note when you see it test, I think, does have to come into play to some degree.
Can I
case
ask
law-
a couple of specific questions that might help that analysis, or at least it would help in my mind? And I want to understand the timing of this. My understanding is that there was the plea, there was a motion filed with the district court during the pending 120 days for probation and a reduction of the sentence, essentially. Is that right?
Correct.
And then that motion was overruled by the district court.
Correct.
Do we know from the record whether Smith's request for an appeal happened before or after the district court ruled on his motion?
I believe that the inference from the defendant's testimony was that his request was before the 120-day call.
Is it an inference, or is it in the record in a way that, or was there a finding
I don't think there was a finding.
as to the timing of the request?
Correct. And I would also note that to be clear, that this is the defendant's burden to establish this record, just so that we're clear.
And would that make any difference in your mind from the state's position, whether or not that request came before or after the district court ruled on his motion?
Under the facts of this case, ultimately, it would not.
Okay.
I think that taking no action after a purported request for appeal for this period of time.
Well, it seems to me you used the word acquiescence a few minutes ago, and it would seem to me that if the request to his attorney to file an appeal came prior to what the district court did, that just strikes me as odd, I guess I would say. In other words, he's got a pending motion for probation. It hasn't been ruled on yet. He testified the only reason he pled no contest was to get a favorable sentencing disposition.
Right.
Why is he talking to his attorney about an appeal?
Why is he or why isn't he?
Why is it would seem to make, and I realize we're just speculating here, none of this is in the record, but it would seem that his interest in an appeal would typically, it would seem to me, arise after losing his motion for probation in district court.
I think that's correct, but I think it could have also.
So where are you drawing this inference that the request came before?
It was from his direct testimony that it indicated that, I believe it indicated he wanted to take an appeal immediately after sentencing. Now, whether he specified which.
Couldn't that be immediately after sentencing, i.e. immediately after the expiration of the 120 days?
Theoretically, I suppose that it could have been.
My understanding was that what his attorney says, no, wait till the callback. And so he did. But his acknowledgement of rights and entry of plea specifically said that he retained the right to appeal the sentence. So he was advised of that.
Correct.
Before he went to KRDC.
Correct. And his acknowledgement included an advisement that of the 120-day callback, and that he would still have the right to appeal after that point in time too.
But my problem here is that, Ortiz is available because the court has to advise an attorney, or has to advise a defendant that he or she can appeal, and that an attorney will be appointed if he or she wants it, correct?
Correct.
And if they're advised of that and request that attorney to file the appeal that they have a right to have, why is it that we're saying basically if the attorney doesn't do it, that they have to do something pro se? That they have to file something with the court pro se? When they've been told that, hey, we'll give you an attorney to help you with this. But right now we're saying that if that attorney doesn't do it, the defendant has to, and really effectively, the only way anything could have happened is if they would have filed something with the district court pro se. Really. I mean, it's a practical matter.
And I think the short answer is because unless they do something, we don't have a third Ortiz exception. If he's requested his attorney to do something, the attorney does nothing, we, Your Honors, the state has no clue that this failure, alleged failure, has occurred unless they do something. They've got to do something to bring this to the court's attention.
And that happened here, but you're just saying that there's a time limit for
There's-
doing the something that they were told the attorney would do for them.
There's a time limit and a corresponding prejudice to the state in waiting.
What if a request was made, I'm indigent, I want counsel to perfect an appeal, and the judge never got around to appointing counsel, and 19 years later the defendant said, wait a minute, I should have had counsel?
Well, first I would say that hypothetical obviously isn't this case, but
That's
I think,
why I ask it.
yeah, and I think that we may have a similar situation because at some point in time, you have to do something. You have to express a desire for relief. That's how things work. That's the only way we can work. Is if we know that a problem exists so that we can do something about it. If you wait for 19 years and place one or the other parties in a position where they are prejudiced and cannot rebut any claims, then that's not appropriate. It defeats the fundamental fairness that was the foundation of the Ortiz exceptions to begin with. So I think the result would be a waiver in Your Honor's hypothetical as well.
Very well. Any further presentation?
I'm out of time. If the court has no further questions, I would simply request that the ruling of the district court be upheld.
Any more questions? I see none. Thank you, counsel.
Thank you, Your Honors.
I'm prepared to waive rebuttal.
Do we have any questions of counsel?
Yeah, what, is there something in the record to indicate when the request for appeal was made?
Yes, it's volume 6, page 6, where the defendant says after sentencing, the sentencing hearing, he wanted to appeal and talk to his attorney about it.
Is that the hearing at which his motion was overruled?
Yes.
Okay.
I see no more questions.
Say that again, that was at the hearing in which his motion was overruled, not the original sentence where the consecutive sentences were imposed. It was there's two sentencing.
Oh, okay.
Which one are we talking about?
I'm sorry, I thought Justice Siegel was referring to the Ortiz hearing.
No,
No.
I'm
That
talking
was the
about the
defendant's
sentencing.
testimony at the Ortiz hearing. There was no hearing on the 120
That's what I
day.
thought. So there's no. So
Okay.
it was. That's what I thought. So we're talking about in his recollection, his request for an appeal was after when the first sentence was imposed,
Right.
and the denial of the probation. That motion did not result in a hearing in front of the court. That was my understanding, and that he never had any contact with his lawyer after the sentencing. Is that right?
And yes, and after the 120 days, he never had any contact with his lawyer either.
And there
his
was no
testimony.
hearing and no contact with
Right.
his lawyer. Okay, I just wanted to get a clarification of where we're at. All right, thank you.
Right, thank you.
Any more questions? All right, thank you, counsel. Thank you both for your arguments this morning. Court will take this matter under advisement.